Okay, so welcome to the beginning of the section of this intellectual property class that's going to be our discussion of patent law. So in this video, I'll give you a kind of brief overview of how the patent system works, and in subsequent classes, we'll talk about the procedural and substantive requirements for patents, as well as patent infringement and so on. Patents and copyrights are the two forms of intellectual property right specifically mentioned in the Constitution, and mentioned insofar as the Constitution explicitly gives Congress the authority to create those forms of intellectual property rights in the Intellectual Property Clause in Article 1, Section 8. Clause 8. Interesting side note, you have to read the intellectual property clause in kind of historical context in order to understand what it's doing. So it talks about promoting the progress of science and the useful arts. Today, we think of patents as primarily going to science and copyright as going to the arts, but in the parlance of 18th century legal discourse, progress of science was seen as knowledge, and copyright was seen as protecting knowledge, and the useful arts was understood as being technology and various kinds of discoveries. And therefore, if you read the intellectual property clause in parallel, you can see that the phrase in the IP clause that goes to patent law is actually the useful arts, which authorizes Congress to give inventors the exclusive right to their discoveries for a limited period of time. In any case, the very existence of the intellectual property clause reflects the extent to which the framers of the Constitution saw the right to create patents and copyrights as being an important right, but also one sufficiently troubling or sufficiently important to mention in the context of the exclusive rights or the powers of Congress, with the implication that perhaps in the absence of such authorization, Congress would not be empowered to create these kinds of rights, a kind of a reflection of the idea that normally people would be able to engage in this kind of activity without being controlled by the law. So, right, the idea that copyright and patent wouldn't exist unless Congress both had the authority to create them and actually did, in part because knowledge of both ideas and of how to implement them normally would be free to everyone to use. And because copyright and patent restrict those rights, there's a kind of constitutional requirement that Congress be authorized to do it. Okay, well, so let's briefly just remind you of the different theories of why we have intellectual property rights in the first place. The two core kind of theories of justification for intellectual property rights being the consequentialist and non-consequentialist theories. Typically, we tend to think in the United States of intellectual property rights, or at least articulate the justification of intellectual property rights in consequentialist terms. However, there's often a non-consequentialist overlay to the way we actually think about those rights in practice, right? So maybe think about what we say and what we do, and how those two may not always be entirely consonant with each other. Of course, alternative justifications like natural rights arguments and moral rights arguments going to the idea that when people discover things, then their discovery entitles them to certain exclusive rights. And in addition, that there's a kind of moral overlay to giving people exclusive rights over both the works of authorship that they generate, but also perhaps the inventions and discoveries that they come up with. In any case, thinking specifically about patent law, right? How might we think about why patent law would be, or granting patents would be, justified in the first instance? So the canonical justification is simply subsidizing innovation, right? The idea being that innovation is dynamically efficient insofar as it increases the available wealth for everybody. So it's not just statically efficient. In other words, the resources going to the people who can use them the best, but dynamically inefficient insofar as it increases our ability to generate wealth in the first place. So we want to encourage investment in innovation, but in the absence of some form of protection, the costs of innovation, the costs of development can't be recouped by the individual or companies that invest in that innovation, and therefore we're going to see market failures in innovation. Right, we'll see underinvestment in innovation if the investors can't recover what they've invested. Therefore, the idea is we create patent protection in order to enable marginal innovators to internalize some or all of the positive externalities associated with the innovation that they generate. In other words, if you come up with a valuable invention, we have patent law to ensure that you can internalize, you can claim some or all of the value, the economic value associated with that innovation. And by doing so, we indirectly subsidize innovation. In other words, we say, if you invest in innovation and happen to come up with something valuable, then the law will enable you to claim that value. It doesn't promise you any value. It only says make the decision yourself, right? Make the decision to invest, knowing that if you invest successfully, that it will benefit you. In addition, patent law also has the benefit of disclosure, and this is an important benefit to think about the trade secret regime that we just discussed, right? Recall that when it comes to trade secrets, the ability to claim trade secret protection is premised fundamentally on keeping that information secret. In other words, if you come up with a new invention, you can use trade secret law to protect it, but only if you don't disclose it to anyone else, because we don't want people to be able to claim trade secret protection over information that's well known, but that has a potentially unwelcome side effect of limiting disclosure, right? I mean, part of the value here is making new inventions available to the public, and the trade secret regime is specifically counter to that value. One big benefit of the patent law regime is that fundamental to patent protection is disclosure. In other words, in order to get a patent, you have to tell the entire world what you invented and how it works, right? So the patent regime is fundamentally a disclosure regime. We give patent owners certain exclusive rights, in part in exchange not only for investing in innovation, but also for disclosing their innovation to the world, right? So part of granting patent protection is ensuring that ideas are available to everyone so that everyone can build upon them. And part of the assumption then of patent protection is that when we grant patents, that kind of property ownership will also facilitate licensing or the transfer of information and technology from one party to another. So in a perfect Coasian transaction cost-free world, right, everyone who has certain exclusive rights over different patentable inventions and discoveries will share or license those rights to anyone else who wants to use them. And the consequence will be a happy confluence of interests where all innovators are in a position to bargain for the various rights that they need. Now, of course, as we all know, that perfect Coasian transaction cost-free world doesn't and can't exist. And in fact, Coase's entire point was that transactions costs are inevitable, and that what we ought to be doing, or we must be doing if we want to increase efficiency, is to think about how to reduce transactions costs, not imagine a world without them. So then the question becomes, do patents in fact facilitate licensing, or do they make it more difficult? You know, in the abstract, it seems like having defined property rights does make it easier for individual parties to come to agreements about how those rights will be allocated. The problem is when there's too many rights out there, then it can be hard for all those parties to find each other and efficiently negotiate. And that proliferation of patents, which can complicate the ability to engage in economically productive transactions, is known as a patent thicket, right? The concern being that if there's too many patents, it'll be difficult to kind of work your way through the thicket as an innovator or potential innovator and figure out who you need to get licenses from and actually to engage in the licensing or the negotiations necessary to obtain a license. And, this is not a purely idle concern, right? You think of a technological device like a cell phone. It's well known that a cell phone can embody or does embody tens of thousands of different patents that are implicated by the technology in the cell phone. But with all those different patents, how do we ensure that parties can adequately negotiate to reach agreements that enable everyone to use the relevant technology? It seems like it happened because we have cell phones. Question is, how did it happen, and did patents facilitate or hinder that from happening? And did they potentially create any limitations or costs associated with that happening? As a digression, right? I mean, one way that's facilitated is by the creation of what's known as patent pools, where the players in different industries will come together and agree to share patented inventions with each other. That's great insofar as it reduces transactions costs on players within the market. The question is, does that then de facto play some role in excluding new entrants into a market? This could be a problem we ought to think about and be concerned about when it comes to practical patent policy. And then finally, there might be concerns about natural or moral rights. In other words, when you've invested the time and labor in generating an invention or discovery, does and should the law recognize any sort of natural or moral rights in the invention or discovery simply by virtue of you having discovered it? Not in relation to the kind of consequentialist goals of the other justifications, but purely in light of the fact that you have brought this to light and invested in its production. Okay, well, in any case, another way in which patent protection is unique and different from other forms of intellectual property rights is how you go about getting it. So we've already talked about trade secret protection. How do you get a trade secret? Well, simply by having valuable information and keeping it secret, right? In other words, the government doesn't have to create it. You automatically get protection by virtue of generating the information and not disclosing it or engaging in reasonable efforts to maintain its secrecy. And much the same is true when it comes to the creation of other forms of intellectual property right. In other words, in order to get a copyright, all you have to do is make a creative work, create an original work of authorship. As soon as you create the original work of authorship, you become the copyright owner in that work. You don't have to ask the government to give it to you. Now, you can register a work with the Copyright Office, but the Copyright Office isn't creating the copyright. It's simply recognizing the validity of your claim to own it. Likewise, when it comes to trademark protection, all you have to do in order to own a trademark is to use a distinctive mark in commerce. Once you do that, you receive common law trademark protection. Of course, again, you can register your trademark with the US PTO, but you don't have to in order to claim trademark protection. And the PTO isn't giving you a trademark, it's simply recognizing the legitimacy of your claim, or the expected legitimacy, at least, of your claim to own a trademark over the use of a distinctive mark in a particular context with respect to particular products or services, right? So it isn't creating the trademark, it's simply recognizing the existence of the trademark. And the right of publicity, which we'll talk about at the end of the class, likewise comes into existence purely as a function of the fact that a person has become a celebrity and their name and likeness has become valuable. The government doesn't create it, the marketplace for celebrity does. Patent law is different, right? There's no such thing as a common law patent. Patents don't come into existence just because you invented or discovered something. In fact, if you invented or discovered something and disclose it without applying for patent protection, you don't and can't get a patent. in what you've invented or discovered. The only way to get a patent is by applying for one with the Patent and Trademark Office, right? And only the Patent and Trademark Office can grant patent protection, right? So in order to become a patent owner, you, the inventor, have to apply with the USPTO and prove to the PTO that you are entitled to the issuance of a patent. And only if and when you convince the PTO that you are in fact entitled to patent protection, will that patent issue and will you be able to enforce it. Okay, now of course there are different kinds of patent protection. Utility patents are the most common and well-known, and typically what people mean when they say a patent. And utility patents protect new and useful inventions and discoveries, but those aren't the only kinds of patents, right? There's also design patents, which protect new ornamental designs, and plant patents, which protect new plant varieties. They're less well-known than utility patents, but they're also really important and increasingly important over time, for better or for worse. And we'll talk about whether we should be happy about that increased importance or not, and whether or not design and plant patents are in fact efficient ways of encouraging innovation in their respective spheres of endeavor. But nonetheless, when you talk about patents, it's a good idea to specify what kind of patent you're talking about. We'll focus in this section of the class on utility patents, and there are certain substantive requirements for a utility patent to issue, right? In other words, you need to show that you have adequate support provided in the patent application for the patent you're claiming. In other words, you have to describe the invention and show how you've invented something new that is actually substantiating the claims in the patent application. You have to show that the invention or discovery in question is in fact patentable subject matter. In other words, the kind of things that patents can protect in the first place. And that doesn't mean anything, right? So not all inventions or discoveries are even potentially patentable. And we'll talk about the patentable subject matter requirement and how and why it excludes certain kinds of inventions or discoveries from patentability. The invention then also has to be useful, novel, and non-obvious. In other words, you have to be able to do something and do something legitimate with the invention or discovery. It has to be new. In other words, not otherwise known to the public already, because you can't patent something that is already known to the public. Once it's known, it's not patentable, and because we don't want to remove existing public knowledge from the public domain. And it also has to be non-obvious. In other words, you can't publish something you can't patent something that anyone who thought about, or anyone who's a person having skill in the art in question would be able to come up with themselves after reflecting on it briefly, right? So it has to be new and non-obvious. Okay, each patent document, which we'll look at in class, a particular patent document has certain elements. One of those elements is a patent number. So all patents are numbered consecutively, but utility patents, design patents, and plant patents are numbered consecutively in different series, right? So one easy way to tell the difference between a utility patent, a design patent, and a plant patent is simply to look at the patent number. So for example, if there is no special designation, if it's just US patent number, whatever, usually something in the tens of millions at this point, then you're looking at a utility patent. However, if you see a D and a lower number, then what you're looking at is a design patent. So simply looking at the patent number can tell you something important about what kind of patent you're looking at. And that matters because the rules and substance of the rules governing and the substance of different kinds of patents is fundamentally different, right? So you really need to know whether you're looking at, for example, a utility patent or design patent, because the law governing the two is going to be not the same at all, right? You also have the title of the patent, the inventor's names and their assignee, right? So patents always have to be issued in the name of the inventor, but of course, inventors can do that on behalf of their employer and assign their patent rights to their employer, which is very common. You also have a filing date and a date of grant, right? So both when you applied for and when the patent was actually issued. A listing of prior art, that's other inventions in the field that limit the scope of the patent claims by virtue of reflecting things that were already known to the public, by virtue of either having been disclosed in a patent or disclosed in some other way, right? Any additional publications that might inform the patent application, the name of the examiner, the abstract is sort of a brief description of the patent, and the specification, which is a more fulsome description of the patented invention or discovery. And then finally, probably the most critical part of the patent, because it defines the scope of the property rights, such as they are in the patent, you have the claims, right? And that can be one or more claim in the patent, and each one of those claims takes the form of a single sentence laying out all of the elements of the claim in question. And what the patent claims do is specify, define what property right the patent applicant is actually claiming that they should be granted, and what the patent office thinks that based on the patent application, that patent owner, that patent applicant is entitled to own. Right? So the patent claims define the scope of the property right, and they also define what can potentially infringe the patent. In other words, you only have infringed the patent if you do what the claims specify without the permission of the patent owner. And we'll talk about that extensively in upcoming classes. Now, how in practice do you go about actually getting a patent? Well, you have to apply for it, right? And then the patent office, patent examiner, will look at your application and decide whether or not to grant the patent in question. Now, typically they don't grant right away. The examiner will respond with correspondence, indicating places where they think the application may need additional development, or pushing back on some of the patent claims, questioning whether the claims are too broad or whether they're justified by the specification. There will be a back and forth between the patent applicant and the office, and either the patent will be issued, which frequently happens, or will ultimately be denied. It will be rejected by the patent office. If the patent application is denied, there is an internal system of appeals within the patent office to the Patent Trial and Appeal Board, which is the kind of administrative appeal body within the patent office. And then subsequently, the patent applicant can also appeal outside the patent office to the federal court system, first to the United States Courts of Appeals for the Federal Circuit, which is the circuit court which has exclusive jurisdiction over all patent law appeals, and then finally to the Supreme Court as well. What happens if a patent is infringed? Well, you can both get money damages and a potential injunction for patent infringement, like you could with the infringement of any other property right. Sometimes the damages will be adequate. Other times receiving an injunction is necessary for the patent owner, or is perceived as necessary for the patent owner to fully vindicate their property interest under the circumstances. And there's been considerable discussion of how the standards for injunctions as explicated by the Supreme Court, especially in the recent eBay decision, might inform whether and when and why an injunction issuing might or might not be appropriate. Okay, so in preparation for class, I would like you to look at the Hoteling 732 patent for a measuring cup that is included in the casebook. I would like you to read that patent document carefully, and I would like you to look at the images for the patent document, and we will discuss them more extensively in class.